Financial Industry Regulatory Authority Incorporated against Fiero. Yes. Good afternoon.
Good afternoon, Your Honors. My name is Brian Graifman of Gus Ray Kaplan Bruno Nussbaum PLLC for the Fieros, and I'd like to reserve 3 minutes if I may.
3 minutes, certainly. Which issue do we start with? Subject matter jurisdiction?
I think so, Your Honor.
Preemption?
I think that's the principal issue that I would think to argue here, and that is that under the plain language of Section 27 of the Securities Exchange Act, this suit by the NASD to recover a disciplinary fine is a suit to enforce a liability created by the Act or rules and regulations thereunder, and thus jurisdiction lies exclusively in federal court.
What should the respondent have done then, in your view, if they wanted to collect this fine?
Well, they could have gone to federal court.
Do you know why they didn't?
I don't.
Don't they need an SEC order to go to federal court under the federal statute?
Well, we would, yes, the Act does provide for the SEC to enforce liability, and if we were in federal court, we would argue that.
Well, the statute for the federal district court says they can review an SEC order.
That's correct, and they can also do
It
so.
doesn't say an NASD determination.
Well, actually, the SEC, I believe, there's a provision that allows in Section 21 of the Act for the SEC to collect awards even of the NASD.
But that's been after there's been an appeal to the SEC, correct? And the SEC has affirmed the award, and then they can go into the Second Circuit or whatever circuit.
Well,
but in this situation, where it's the NAC that's seeking the recovery, what would they have to do? Would they have to go to the district court and start a plenary proceeding?
We would say that they would, and we would say that they would be unsuccessful in doing so. Yes.
Oh, you would say they'd be unsuccessful in doing that too?
On the merits.
So they have no remedy.
No, but you're saying there'd be jurisdiction.
Yeah, on the jurisdiction, they should go to federal court.
You would not raise an objection had the same proceeding been brought in the federal district court?
I don't know that I'd be prepared to answer that yet. It's possible that under the statutory scheme, there is no remedy, and possibly
it's your job to find objections. So you might try to find one.
I would look for objections, and I don't want to bind
You would say no jurisdiction in the state court and no jurisdiction in the federal court.
Well, certainly there's no jurisdiction in the state court, because under the statutory scheme, Section 15 of the Securities Exchange Act, Congress stated that if you want to transact securities on an exchange, you have to be a member of you have to be registered with the SEC, and if you want for the SEC to grant registration, you have to be a member of the National Securities Association. And Congress also stated in Section 15 of the Act, by the way, when you register with the SEC, you have to do so on forms that the SEC shall prescribe. And in Section 15, large A of the Act, which we discuss at page 11 of our brief, Congress defined the National Securities Association, the one you have to become a member of if you want to transact on a securities exchange, and also stated in that section that that the NASD, or the National Securities Association, shall promulgate disciplinary procedures, and that's in subsection B7 of Section 15, large A of the Act. And Congress also stated that those disciplinary procedures shall be for violations of, among other things, violations of the Act, rules and regulations thereunder, or violations of the rules of the exchange. And under that same section, Congress stated among the possible sanctions is a fine. And that's Section 15A of the Act. Now, the NASD, pursuant to SEC oversight, Section 19 of the Act, which we discuss at page 12 of our brief, promulgates the disciplinary and adjudicatory procedures and exercises them here also under SEC supervision and imposes the fine that Congress provided for in Section 15A. And that is how the NASD obtained this liability. It was created.
You're saying that this obligation originates in federal law.
That's correct.
That's the point of what you're saying.
Yes. Now, the NASD, go ahead.
And it can't be enforced in state courts.
That's correct, Your Honor. The NASD would say that it's contractual.
You would say, you take the position, which I guess some of us would have a hard time with, that if you don't appeal from the NASD imposition of the fine becomes unenforceable. They can't sue anywhere.
Well, that's what they've been doing for the last 65 years.
I understand, but assuming you lose on that, assuming that they do have a right somewhere, you're saying the right has to be in a preliminary action in federal district court?
Yes, Your Honor.
Let me follow up on that, though. Who should be filing in federal court? The NASD, the NAC, or the SEC?
Well, it would be the NASD or the SEC. And I believe the SEC does have jurisdiction to collect on an NASD award.
I wonder if you could read it in such a fashion that the NASD, upon your failure, upon a person's failure to pay the fine, should then either be writing to or petitioning the SEC, saying to them, enforce this for us, because we're your creature. We're your administrative body that has made a determination, and it's your job, SEC, because you have the oversight of us and nationally, to commence an action in the appropriate federal court, not the NASD.
Well, that is a route that they could take, and I would have defenses
but you wouldn't
that
quarrel.
is a route they could take.
Well, you might quarrel, but right now, at least in your view, the NASD has the authority to go to federal court. May have the authority.
Well, if they have the authority to go anywhere, it would be to federal court.
What particular statute are you saying establishes this exclusive jurisdiction in the federal court?
Section 27 of the Securities Exchange Act states that any suit to enforce a liability created under this act or the rules or regulations thereunder. And basically, this is actually one of the unusual cases.
That's pretty broad language. There isn't any statute that's more particular?
Well, actually, I don't know. There actually are broader statutes for exclusive federal jurisdiction, but in light of this fact pattern, that is a broad statute because this fact pattern fits squarely within it. Now, the only thing is the NASD is coming in and saying that this is a contractual liability.
Yes, I was going to ask you about that.
Right.
Why isn't that so under the forms that are signed by your clients?
Because, well, for one thing, the forms are provided for in the federal statute under Section 15, large A, subsection B7. And what happened in this case, in fact, we had counterclaims which were contractually based. And the NASD jumped up and said, no, we were acting as a regulator under the Securities Exchange Act. We're immune. And the judge below, Judge Edmead, and it's in the record at page 25 of the record, dismissed our contractual counterclaims on that basis, and it was affirmed by the appellate division at page 737.
Do you have a cross appeal on that?
Nobody appealed that. So that's.
But that could be wrong too.
Well,
And then where does your argument lie about the contract?
Where the argument lies is the NASD always understood it wasn't contractual because if you look at their complaint and their amended complaint here at page 81 of the record, there is no traditional cause of action asserted. What the NASD states is, here's the Form U4 and the Form BD, by the way, the forms that Congress stated the SEC shall prescribe. Here's the two disciplinary decisions, the decisions within the structure and procedures that the Securities Act states that the National Securities Association shall promulgate. Give us our money. And the irony is that there is no real contractual provision because if you look at the NASD arbitration rules, there's a section called awards that states any such award may be entered as a judgment in any court of competent jurisdiction. And that's Rule 10.330 of the arbitration rules. And under the new industry and customer rules, it's the last rule in those sections.
Mr. Graifman, I know there are a couple of decisions in the state here. Has this been attempted anywhere else?
We are not aware, and we've looked, we're not aware of any other NASD action except for the handful that were recently filed in this state. And we did look.
Isn't the U4 says in it, I apply for registration and in consideration, use of the word consideration, of the jurisdictions and organizations receiving and considering my application. I submit to the authority. I agree to be subject and comply with requirements. I agree to penalties. Why isn't that a contract?
Well, first of all, again, penalties, and if I can go back a step and just I'll connect this to your thought, to your suggestion, Judge Smith. In the Act, they also provide for the SEC to collect, and there's a section actually called Collection of Penalties, which provides the U.S. Attorney General can apply on behalf of the NASD, or I'm sure, on behalf of the SEC.
Can't there be both a statutory right to collect the penalty and a contractual right?
Well, the problem with that is, if you, this court in the Geese case decided, and other cases have decided as well, that common law causes of actions that overlap with the federal securities law are preempted. And here you have the federal regulator actually.
Well, there could be theoretically, it could be a contract and it could be federal, couldn't it?
Well, except the courts below determined there is no contractual right because it's basically overridden by the federal statute, which is quite clear in its scope here. And the NASD in their own complaint didn't even attempt to assert a contractual cause of action. And
So your client can avoid payment of these fees indefinitely?
No, well, they cannot go back, if they're not in the industry, if they attempt to go back in the industry, then they can collect.
No longer in the industry.
That's been the rule since 1939.
It's been a policy, and there's been a change in the policy.
Well, but that goes to another issue, of course, which is our third point, which is whether they had to get that rule authorized by the SEC. But in terms of who has the right to look at that question, I think it's under the clear, plain language of Section 27. So you have express preemption and under implied preemption, even conflict, as this court found in the Geese case. There are 49 sister states who can come out with another determination as to the authority of the NASD.
Is it possible that your client did not further appeal this to the SEC because he felt that, you know, the appeal would be fruitless, and in a way to avoid the payment of the fines,
I
would be by just staying put and not appealing any further?
I think one of the considerations was that the SEC had the right to ask for review on its own. We didn't approach the SEC, and the NASD didn't, and I don't think they actually could. But the thing is, if this court...
So they've done whatever they can, whatever they feel they can do, other than going into federal court.
Well, they have other routes. They can have the rule approved, like their arbitration rule that says any penalty here shall be enforced in any court of competent jurisdiction as a judgment. They could do what Congress did in the act as to the SEC collecting, say enforcement of penalties. We were going to, the Attorney General can go and enforce penalties. They have nothing like that in their rules, and they've never gone to the SEC, as far as we know, and said, change our rules so we can have what we have in our arbitration rules, so we can have what the SEC has in the act.
Isn't the power to collect a fine sort of implicit in the power to impose a fine?
Well, actually, we cite cases that say the two are not the same. You can impose a fine in an organization, and if you don't pay it, they kick you out. And they don't have, courts have rejected it on that basis. So if you open the door to the NASD here, you'll have every SRO knocking at your door, not only in the securities field, but the commodities field, and you'll be having the American Stock Exchange, the National Futures Association, the New York Mercantile Exchange, the ICE Futures, which has part of the old New York Board of Trade, NASDAQ, just to list a few.
Well, the downside of that is what? I mean, we have filing fees, too.
You do, but I don't think they cover the budgetary requirements.
Well, what is the problem with that? Because these are just flat-out collection actions. I mean, they're not saying that the state courts have any ability to review what the NASD or NAC found, or the amount of the fine, or that there should be a fine. It's just a pure out-and-out collection.
Well, yes, but you'd have to determine whether they have the authority to collect in light of the history, in light of...
Yeah, but assuming that we find that they do, it's a pretty cut and dried legal action.
Well, yeah, but that's sort of wagging the dog by the tail.
No, I thought you were arguing we were opening up floodgates in the New York courts. That's all. I was responding to that. And it seems to me they'd be pretty cut and dried actions.
Well, they would be, except for the defenses that would be asserted.
But what you want to say, though, is that the floodgates ought to open on the federal side. In other words, you're not saying there's no dearth of work here. You're just saying, why should you take it on when the feds can do it, or should do it?
That's correct, Judge Pickett.
Or might be able to do it.
Might be able to do it.
Right.
And have there been enforcement actions in the federal courts?
We are aware of none. By the SEC, there have, yes.
In any district court in the country?
We're not aware of any.
So this is the first time it's ever come up. It came up in New York. In
Yeah.
this case, and you said there's some others?
Yes, they're in the record. There were some others. There have been defaults. People really didn't know how to handle it, I guess. But
In this case, did all the conduct complained of happen in New York, the underlying conduct?
I believe all the conduct did happen. There may have been some New Jersey nexus, I can't remember, but there was definitely in New York, and it also involved federal securities laws.
And all these other exchanges that you mentioned a few moments ago, attempting to make the floodgates argument, they've never come into any other state or federal court either? Ever?
We're not aware of them coming into state court.
This is the first time in the history of the world?
I cannot answer the question as to what they do in federal court. We did
You
a few
haven't-
searches
you
in
haven't
state
looked
court,
at the
nothing
federal-
came up. Nothing came up. And I'd also mention that this is, on the preemption analysis, this is the last point on that there's no class of plaintiff that would be curtailed from state court other than an SRO or maybe a securities exchange under the Act. And under the plain language of Section 27, this would belong exclusively in federal court. Just for completeness, I'd like to add one point to the arbitration issue, which is that the disciplinary procedure is an arbitration enforceable within 1 year. This court's own rules for attorney-client fee disputes provides for arbitration with the possibility for de novo court review. So even though there's a different route of review than Article 75 of the CPLR, a different standard of review, that is de novo, that award would still be an arbitration award, as it's called, and enforceable, if at all, only within 1 year.
What's the statute of limitations in federal court, in your view, in these cases?
Well, the SEC has a 5-year, there's a provision for the SEC for 5 years.
So that's what you would not argue there, but maybe argue here. I mean, it's 5 years from the date of the judgment, or the date of the award?
I don't know the answer to that question, but it's 5 years.
5 years.
So we could say that the state courts have jurisdiction, but statute of limitations is only 1 year, and that would preclude the claim.
That would be, that's our argument on the merits, that they were too late. They came in 14 months after the award.
Those are basically the arguments you made below, isn't that good? The whole question of subject matter jurisdiction didn't come up in the first department, is that right?
That's correct. It didn't come up until after this court granted leave to appeal. I showed the brief to Elliot Wales, who suddenly divined the hidden issue that we apparently overlooked. Thank you.
Ms. Reischer?
May it please the Court. My name is Terry Riker. I represent the Plaintiff Respondent Financial Industry Regulatory Authority. For purposes of this case, I'll continue to refer to us as NASD. I also, prior to the argument, I provided several cases that I'm going to mention in this argument that were not cited in our briefs. I have provided copies of those published cases to the clerk. There's enough copies for everyone.
Is this the first time that you folks have sought to enforce a fine in a state court?
No, actually it is not, Your Honor. We had a collection program in the early 1990s. Unfortunately, those records, I didn't bring those up below because those records were all residing with our law firm in the World Trade Center, and those records don't exist anymore. But we did have a collection program at that point. I'm not sure how successful it was. We have had a collection.
Are there any published decisions in other states?
Not that I am aware of. We do have an active collection program. We do routinely refer disciplinary cases out for collection. The determination
Have you ever tried federal court?
Not that I don't believe we've ever.
Could you if you wanted to? Could you have brought this case in federal court if you wanted to?
We could have. There was diversity jurisdiction.
Well, could you under federal question jurisdiction?
We would try to assert it under federal question jurisdiction. I think we would definitely do it under diversity.
That would be on the theory that it's a liability originating under the Exchange Act.
That it arises, not necessarily, but that it arises so that it's related to a disciplinary case. I
mean, it seems if there's federal jurisdiction, wouldn't it have to be exclusive? Don't you have to be stuck with one or the other? Can you have both?
No, yes, absolutely you can, Your Honor. As a matter of fact, the courts of this state do recognize that there are dual roles for state and federal courts in the area of securities law, even where violations of NASD rules are alleged. And one of the cases that I have provided the court is People v. Cohen, which is 773 New York Supplement 2nd at 371. It's a First Department case, and in that case, the First Department held that an oath given in an NASD disciplinary testimony could be the basis for a state law perjury conviction, and it was not subject to exclusive federal jurisdiction.
Ms. Riker, before you leave your active collection program, you say that went on in other states as well. Did it, as well as New York?
While we have referred matters to collection in other states, I don't believe we have filed suit, but the decisions to initiate collection proceedings are based upon a number of things that you base any collection action on, which is the amount, the ability to collect, the ascertainment
Right, but there's
of
only
assets.
the one or two reported decisions?
I'm not aware of any.
Not aware of any.
We do have collection program, and the record has, I believe, 4 collection actions that were initiated in New York Supreme Court.
How do we
Been
know?
successful in all of them, right?
We have judgments.
How do we know what law applies to the state claim? Which state's law?
In this case, it depends on the aspect.
In this case, it's easy. Suppose it were not so easy.
State contract, since it's breach of contract, it's state contract law.
So if you had a lot of contacts with Florida and a lot of contacts with New York, and you were in a New York court, the New York court would apply its conflicts test.
I believe, with respect to the contract, with respect to breach of contract, yes.
It's implicit in your theory that that when he signed the U4, he created a contractual right under the law of some state, and you'd have to apply a state choice of law rules to figure out which state.
Absolutely, Your Honor.
Isn't there some interest in uniformity here?
There is in uniformity with respect to the underlying disciplinary proceeding, and that was preserved because that is subject to federal law. That is subject to the administrative procedures that are laid out in the Exchange Act. But that did result in uniform application, but that disciplinary case concluded in 2002.
Even in collection actions, isn't there some? Doesn't your client have some interest in knowing, for example, how long the statute of limitations is? Why should that depend on state law?
Unless there is a state law provision in the contract, then it would depend on the place where the contract is.
And there is no state choice of law provision in the contract.
No, there is not.
But doesn't that suggest to you that the very, very sophisticated authors of that document weren't contemplating a state law action?
No, not necessarily, Your Honor. And as a corporation, NASD does.
Most sophisticated drafters of contracts will put in choice of law clauses.
That is correct, and we were the sophisticated drafters of the U4 along with the states, and why that wasn't, why that is not in there doesn't mean that it wasn't.
Isn't the natural assumption that this is a federal thing? I mean, you exist by virtue of federal law. The NASD is almost a creature of federal law.
Actually, the First Department has found that we are a non-governmental agency, that we are regulated by the SEC, we are authorized by the Exchange Act, but that we are a private corporation that has the rights of private corporations, and one of those rights is the right to sue and be sued in state court to enforce contracts.
You also are quasi-governmental, are you not?
It depends on, the cases in New York say that we are a private corporation.
But isn't your whole enforcement authority coming from the SEC?
The authority to bring disciplinary actions, yes, that does spring from the Exchange Act.
Yeah, they could take that away, in theory.
Theoretically,
and
they
give
could,
it to
yes.
someone else. And I'm curious, let's assume someone, you've got some person who buys or sells stock or claims to have been defrauded by somebody and they're in Montana, and you decide because they're in Montana and you don't want to inconvenience them, you're going to bring your disciplinary proceeding in Montana, and therefore you get you find this individual in Montana even though he lives in New York. Now, where do you file the judgment? And why does that ever be a concern? I would think you'd always want to be in federal court. I think you would just naturally say this is our jurisdiction, and once you got your fine and your judgment, you'd go to the SEC, make them do the hard work, say, file this for us. And
That's a choice. I mean, that's the choice of courts is the choice of courts is a separate issue. We could have brought this in federal court. We chose to bring this in state court. That doesn't mean
It's odd to me that you're saying we could have brought it in one court and another when there's a statute that says federal jurisdiction in this area is exclusive.
Well, the statute only says the statute is limited. The Section 28 of the Exchange Act also reserves certain aspects of the enforcement of securities laws to the states. And so Section 27 does not grant a broad exclusive grant of jurisdiction only to federal courts.
let me just, and I apologize, I'm interrupting you again, but if you've got one of my concocted fraud claims, in Montana, and you decide you're going to do the hearing out there because Mr. and Mrs. Kettle don't have the money to get to New York, and you get your judgment and you impose your fines, can the dealer say, I couldn't get to Montana when they had this hearing, and therefore I want to collaterally attack this whole business that the NASD did? Can they do that?
No, they cannot, because that would be part of challenging the underlying disciplinary case, and that is subject to Section 15A and Section 19 of the Exchange
Federal
Act.
law.
They have to do that under exactly. They have to go to the SEC to challenge any aspect of the underlying disciplinary
So
decision.
all of that
That's
is
not this case.
All of that is federal. You want to simply say once the federal machinery has stopped, once the time to appeal has expired, et cetera, we now have a co-ed amount of money that we want to collect, and we can collect it in any state in the union.
We can. It's the determination of where the defendants reside, where there might be assets, what nexus we have. It's how you make a decision to file any state court case.
But now in diversity actions, you can get a judgment in federal court, and then of course you file it in any state where there are assets as well. So it's not.
Yeah, but if we got a judgment in federal court, we would file in the federal court that had personal jurisdiction over that defendant.
And then you can file that judgment anywhere you choose.
Yes, we could.
States.
Same as with the state court
So
judgment.
there's never going to be any affirmative defenses or counterclaims that would have to be removed to the federal court?
I don't believe that any of the counterclaims that could be, at least the counterclaims that were brought in this case, all attacked the underlying disciplinary proceedings, and those could not have been brought because those should have been brought in the disciplinary action which was concluded.
Isn't there a kind of unfairness there?
No, because the Fieros had the opportunity to fully litigate those issues in the administrative proceeding. They decided not to pursue that.
In this particular case.
You were successful with your immunity defense as to those.
I believe immunity, also exhaustion of administrative remedies.
In this particular case, they're asserting, at least in part, that as you argue, you're a private corporation, and never before have you done this. So when they got beat in this proceeding, and they were excluded from being securities dealers anymore, and they were fined this amount of money, they said, okay, we can't afford it, so we'll just decide that we're not going to be security dealers anymore. And this is a total surprise that all of a sudden, for the first time in 65 years, you've decided to impose a fine. Now, that would seem to me to be at least a colorable collateral attack on an application for a judgment in the state of New York, but you're saying it's not because federal law prohibits them from bringing collateral attacks on your applications for judgment in state courts.
They could raise that argument, but it shouldn't. But I guess what the court below found is that it shouldn't have been a surprise because A, it's in our rules, it's in our bylaws, and we specifically provided notice in 1990 and again in 1999 that we would, in appropriate cases, seek to collect fines that were imposed on individuals and firms, even where they were also kicked out of the industry. So there's no issue about that. They did have notice of that. With respect to I think we've probably gone through subject matter jurisdiction. We believe that there is subject matter jurisdiction in state court, although this case could have been brought in either place under People v. Cohen and also more recently the Appellate Division, First Department in People v. Kozlowski.
Can you cite a civil case under the securities laws that could have been brought in either federal or state court? Another one?
Probably one. I'm trying to think. People v. Cohen. That was a securities case.
I said civil.
Civil case. I can't think of anything
I haven't read those cases, but People v. Cohen, you said it's a perjury prosecution?
That was a perjury prosecution, yes.
And so the court there held that a perjury in an NASD proceeding violated state law as well as federal law.
Yes, and People v. Kozlowski said that, affirmed a Martin Act conviction that the defendant, Dennis Kozlowski, said was preempted by federal law and that federal courts had exclusive jurisdiction over his actions. And the First Department rejected that. That's a November 15th opinion. I can't think of a case that is on all fours with this because we haven't had a collection case that has gotten to this level.
Well, but it's not even on all fours. To me, that you have a statute that says the district court shall have exclusive jurisdiction of any suit to enforce a liability created by this chapter of the rules or regulations thereunder. If you're saying you could bring it in federal court, which seems to me that suggests that there is a liability or duty created by the federal law or the rules and regulations thereunder. If there is, why isn't the jurisdiction exclusive?
We are arguing, if we were arguing under Section 21E of the Exchange Act, that might be the case. But what we are arguing is that this is a separate liability which is created by the Fiero's independent contract with NASD in which they agreed to comply with all rules, pay all fines and penalties. So that particular cause of action is a contract and that could be brought in this court.
Does that mean that Mr. Fiero could have sued you in any place, any state you're subject to jurisdiction, which I assume is all of them?
Yes.
He could have sued you in Alaska to say for a declaration that he is not liable to you because the proceeding was improperly conducted, and the Alaska court would have jurisdiction to decide that.
We would argue, at that point, we would argue that he was collaterally attacking the underlying disciplinary proceeding, and in that case, we would remove it.
I'm talking about jurisdiction. You would make that argument. Maybe the judge in Alaska would agree with you. Maybe he wouldn't, but he'd have jurisdiction.
We would argue that we would remove it to federal court at that point and argue that that was federal jurisdiction because it was a collateral attack on the underlying disciplinary proceeding.
You would say that claim was federal, exclusively federal.
Yes, we would say that claim was exclusively federal.
But your claim against him to enforce the contract is not.
No, it is not. It is
So
a state law contract.
a declaratory judgment that he has no contractual liability to you is?
It depends on what it's based on. If it's based on a collateral attack on the underlying disciplinary proceeding, then yes, that would be federal.
I know this doesn't affect this case, but in terms of our going forward rule, is the reorganization this past summer that created FINRA, does that affect the enforcement of these kinds of judgments in the future?
No, it does not. All it did, we absorbed some of the regulatory functions of the New York Stock Exchange. It means that we will regulate more firms and bring additional cases, but it doesn't change the underlying organization or the collection program.
There is no change in the statutory structure?
No, absolutely not.
Has there been any movement to have SEC approval of the rules or regulations that you're asserting here?
Well, the SEC did approve the rules that authorize us to impose fines, and they also approved the rule requiring members to pay the fines. So those rules have been approved for a number of years. No, we don't believe that there's any additional rule that's required to authorize a corporation that's privately incorporated to enforce the collection of those fines.
Why did you change your policy after 64 years?
It wasn't. There were actually been several efforts to have a collection program. The most recent one came, I believe, following a GAO report that tracked collection of fines by all the securities industry. And so shortly after 2000, I believe, we reimposed a collection policy.
Ms. Riker, under your interpretation of the law, what is the statute of limitations for you to enforce these judgments, and from what date does it run?
For us, in this case, it is 6 years from the date that the disciplinary decision became final, which was, I believe, December 2nd, 2002.
By final, you mean when the appeals have been exhausted?
Yes, yes.
Not from the date of the judge, not from the date that the fines were imposed?
The disciplinary decision was issued in October of 2002. It became final 45 days after that, I believe December 2nd.
But the fines were imposed in December of 2000. That date is irrelevant for purposes of
That is irrelevant because everything was stayed while it was on appeal to the National Adjudicatory Council.
Okay.
The NAC decision was issued in October of 2002. I see I'm out of time.
Thank you, Ms. Riker. Mr. Graifman.
Okay, just on those cases that she cited that were criminal cases, perjury in an NASD disciplinary proceeding, the state has a very strong police interest that's always taken into account in a preemption analysis. That's a right created under the criminal laws of the state of New York. When a New York licensed notary administers an oath, that's violated. That's not a right created under the securities statute. It's not a notary statute. It's not a perjury statute. It's a securities statute in the federal statute. The counterclaims that we had did not arise out of the underlying disciplinary proceeding. It was the fact that the NASD had violated and acted outside its authority in facts that are embodied in the Second Circuit decision, which is cited in the record. But let me just state it this way.
You didn't appeal that anyway. Mr. Wales didn't notice that.
Right, but that Second Circuit, oh, you mean the underlying counterclaims? That's correct. We did not appeal that. But she stated that.
And you say today that that was correctly dismissed because it was federal.
Oh, that's what we're bound by because we didn't appeal it. And that's at page 209.
Well, whether you're bound or not.
Right.
What's your position today on whether that's a federal or state claim?
Well, it would have to be that it's not that the NASD acted as as they stated, as the court stated, as the federal regulator at that time.
So your counterclaim was beyond the court's jurisdiction, just as their claim is, in your view.
It would be, yes.
Mr. Graifman, how do you articulate what is preempted, just so we know if we agree with you?
Okay, an SRO seeking to collect the disciplinary award. SRO being a self-regulatory organization which includes the National Securities Association. It's in Section 15 of the Securities Act, Exchange Act. And also, the few cases that were brought in New York State court, most of them were defaults. I think they all were probably defaults, and also pro bono defendants. One of them, the Pincus case, he was pro bono, and I went to the court record to look, and even to the end, he was pro bono.
These are the ones that she referred to.
Pro se. I didn't mean pro bono. Thank you. Pro se.
These are the ones that counsel was referring to that occurred in the early 1990s?
No, these are the ones that were recently.
More recent ones, okay.
I'm not aware of the 1990s, but I am aware of the few that were filed recently. They're in the record.
Your time has expired, but let me ask you a question. If what you say is true, then the NASD would simply go to the SEC and or go to the federal court and get what it can get, what your opponent is claiming it can get tomorrow in a state court. The only thing we're talking about is where that first piece of paper gets filed for a judgment to be enforced in this state.
That's correct.
A purely ministerial issue, and you simply say it's federal, and she says it's tomorrow.
Right, and if you read their first question presented in the NASD brief, you'll see why it's federal. Thank you.
Except you're reserving the right to argue that there's an impediment there, too.
I always am reserving all my rights. Thank you.
Yarborough against City of New York.